Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. It's January 3rd, 2022, our first show of the new year. Let's get to the docket. First, the judge in the Barry Morphew case, he recuses himself, and then the district attorney dismisses the case that started the whole mess. Second, the 110-year sentence for that truck driver, well, the governor gave some clemency. Elaine Maxwell, we all know, she was found guilty last week. How much time is she actually going to get? I'll explain it to you. And then finally, our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Crime Talk, the most fact-driven, unbiased, true crime channel out there on the entire internet. And I mean that, all right? It's the start of the new year, 2022. Let's get this thing rolling. First, if you haven't done so already, hit that subscribe button. Hit that little bell so you receive notifications of when we go live or put up new content. Now, remember, tomorrow we'll go live at 6 p.m. Mountain Time. Please join us. Next, we need to do a little bit of paying the bills, okay? You never know when an emergency is going to happen. Last month, it was the tornadoes in Kentucky. Here we had these crazy grass fires. The little grass fires started in the suburbs of basically Boulder, which is Louisville. And with the huge winds, it burned down nearly 1,000 homes. There's still 2 people unaccounted for. So you never know when basically bad things are going to happen to good people. You need to be prepared, whether it's have a little money stashed away for that emergency, or also having an emergency food supply. I'm telling you, please go to crimetalkprep.com where you can order a 3-month emergency food kit and receive $100 off. I hope you never need this, but this is insurance in case you do. And if there's one thing we figured out over the last 2 years, you don't know what the heck is going to be happening next. It just seems like it keeps on coming. So you have to be prepared. You have to be prepared to take care of your family. Go to crimetalkprep.com. You'll be happy you did. Okay, let's get to the docket right off the new year. Several weeks ago, in the Barry Morphew case, in regards to the death of Suzanne Morphew, the attorneys for Barry Morphew filed a motion to recuse the judge. And let's kind of go over this, okay? So the judge that's been overseeing the case against Barry Morphew, who's charged with murder and the disappearance of his wife, Suzanne, has recused himself from the case. The move followed a request by the defense to have Judge Patrick Murphy barred from any further participation in the case after a conversation between Morphew's defense attorneys and Martin Stewart, the defense attorney for a woman mentioned in Morphew's arrest affidavit. So first, how did all this begin? So back on October 13th of 2021, the court disqualified itself from hearing the case of People v. Shoshone Darke, D-A-R-K-E. I've heard it pronounced 2 different ways, Dark or Darky. You pronounce it whichever way you prefer. Now, this is a case in Chaffee County, and it was a misdemeanor case. And the reason the court disqualified on that case was that the firm that Martin Stewart works for, which is called McDermott, Stewart, and Ward, had entered their appearance on behalf of Shoshone Darke. Now, as the court stated on the record on October 13th, 2021, the court has a long-standing personal relationship with Sean McDermott, who is a partner in the firm of McDermott, Stewart, and Ward. Therefore, the court had to disqualify from the case. A hearing in that case was held on December 14th, 2021, and at that hearing, the court made a record regarding the court's relationship with Mr. McDermott. And for the sake of clarity, I will state exactly what the court stated in its order. And the court stated, the court has known Mr. McDermott for at least 40 years. The court attended the same schools as Mr. McDermott, including high school. Mr. McDermott is a close friend with the court's sister and brother-in-law, and they socialize regularly. Mr. McDermott is the godfather of the court's niece. Mr. McDermott and the court were both deputy state public defenders in the late 90s and early 2000s and talked often about their jobs. Mr. McDermott and the court have spent time together during fishing trips, and they socialize when they are both in Denver. The last time the court saw Mr. McDermott was at a graduation ceremony in May of 2020. 2021. Also discussed at the hearing was the fact that both the prosecution and the defense may call Shoshone Dark as a witness in the case as it relates to Mr. Barry Morphew. Now, as described in the motion and the accompanying affidavit by Ms. Itan, Shoshone Dark was also the subject of at least 2 search warrants, and her alleged relationship with Mr. Morphew was featured in the arrest warrant affidavit. That alleged relationship may be used by the prosecution in the case's presentation at trial. And if Shoshone Dark is called as a witness in this case, her attorney will be present and will be advising her regarding her Fifth Amendment privileges. It is also possible that other legal issues, such as the scope of the immunity, if given, and the scope of testimony, will also have to be decided by the court after advice and input from Mr. Dark's attorney. Although less likely from a legal perspective, it is also possible that Mrs. Dark and her attorney may try to challenge the search warrant issued by the court that involve her or her property. Now, Ms. Itan in her motion stated that the motion was filed on December 13th, 2021 because she only learned about the court's disqualification on the Darkey case on December 9th of 2021. So the Colorado judicial canons also require a judge to disqualify if the judge's impartiality might reasonably be questioned, including situations where the judge has a personal bias concerning a party or a party's attorney. That's specifically Judicial Canon 2.11, paragraph A. Now, in deciding whether to disqualify, the court must consider both the actuality of the conflict as well as the appearance of fairness. Either actual prejudice on the part of the trial judge or its mere appearance can require the disqualification of the judge, even if the judge is entirely convinced of his own impartiality. He must take care not to allow the justice system to be impugned by the appearance of partiality. This concern must be given the highest consideration in ruling on a motion for disqualification to secure the confidence of the litigants as well as the reality of maintaining public respect for the courts. Now, the court in its analysis says there's 2 questions that the court must answer. First, does the court's relationship with Mr. McDermott rise to the level requiring disqualification? And second, does Mr. McDermott's involvement in the case require the courts to disqualify? The answer to the first question is fairly obvious. As recited by the court has a long-standing personal relationship with Mr. McDermott, and because Mr. McDermott's firm represents Mrs. Dark, and because conflicts with one attorney are imputed to a firm, the court disqualifies itself from Miss Darkey's case. Then, if Mr. McDermott or his firm represented Mr. Morphew, the court would clearly have to disqualify from Mr. Morphew's case and would have done so without a motion being filed. Now, it is the second question that is more difficult to answer. The role of Mr. McDermott and his firm is somewhat attenuated in relation to Mr. Morphew's case. The McDermott firm does not represent Mr. Morphew. Instead, they represent a person who may testify at Mr. Morphew's trial and who will likely be part of the prosecution's theory of the case. As stated in the prosecution's original response, disqualification under this circumstance presents a novel legal question in Colorado, and the case law cited by both sides focuses on the first question: does the relationship rise to the level of disqualification? Rather than the second question, is the attorney with whom the judge has a relationship involved enough in this matter at issue to require disqualification? Now, apparently, this issue remains a novel legal question in Colorado, and therefore the court must do its own analysis, as the court explains. The court focuses on the wording of the rule and statute in the judicial canon. The statute states that a judge must disqualify if he is in any way interested or prejudiced with respect to the case, the parties, or counsel. The canon requires disqualification if the judge's impartiality might reasonably be questioned. Now, comments following the canon state a judge will be disqualified whenever the judge's impartiality might reasonably be questioned. Thus, the statute and the rule are very broad in terms of when a judge must disqualify, and the words in any way imply that even if the conflict is attenuated, as in this case here, the court must disqualify. Similarly, the court does not have to attach to the attorney of record on the case at issue. Instead, the conflict can attach with respect to the case. So even though Mr. McDermott's firm is not an attorney for a party to the case, they are involved with respect to the case. Finally, the canon requires the court to recuse even if the court does not believe it has a conflict if the judge's impartiality might reasonably be questioned. Here, At the very least, the court hearing this case will likely have to rule on issues surrounding Mrs. Dark's testimony. The court will have to make those rulings after hearing from Mr. Dark's counsel, and if the court rules in favor of Ms. Dark and her counsel, the argument could be made that the court was doing so because the court favors Ms. Dark and her counsel based upon the court's friendship with Mr. McDermott. Thus, even though the conflict relates to a very small portion of the case, and even though the court does not personally believe the relationship with Mr. McDermott would affect the court finds that it has no choice but to disqualify. Now, the court explored the possibility of disqualifying for only that portion of the case involving Ms. Dark, but declines to do so as the case law does not support such an approach. The court states that once a disqualification occurs, the rule requires the disqualifying judge to notify the chief judge of the district of the disqualification, and then the chief judge's responsibility to appoint a replacement judge if from within the district, or to notify the chief justice if a replacement judge cannot be appointed from within the district. This court, he states, serves as the chief judge of the 11th Judicial District. In order to avoid an extension of the conflict and replacement decision, the court as chief judge entered a chief judge directive in 2017 that transferred the replacement role to the district administrator in the event that the chief judge disqualified himself from a case. Therefore, the court grants the defense motion to disqualify Judge Morphy, and the court will have no further role in the determination of the replacement judge, and the district administrator will contact the chief justice in order to determine who is going to be the replacement judge. All right, so let's talk about what this really means. You would think, all right, we have Iris Eitan and we have Drew Nielsen, who represent Barry Morphew. Barry Morphew's girlfriend is represented by the firm of McDermott, Short, and Ward. Sean McDermott knows the judge. They're family friends. They socialize with one another, but Mr. McDermott is not directly involved in the case and therefore disqualified. You would actually think that it would have been the prosecution moving to recuse the judge in this particular case, but it was the defense. Now, the scary thing is when you recuse a judge, you're not exactly sure who you're going to get, okay? Sometimes the devil that you know is better than the devil that you don't know. Now, everything about this case thus far, I think the judge has ruled correctly on thus far to date. Frankly, I'm not exactly sure why there was an issue. I don't think it rose to the level. I can tell you, I've had cases in front of a judge, one that I had baseball tickets with in a baseball group. He was very nice, professional. When we went to the baseball, he treated my son to anything he wanted when he was very small. Frankly, when I went in front of him in court, I always felt like he gave me a harder time because he was overcompensating, but he never thought that our brief interactions resulted in a conflict. I've done cases in front of a judge who I represented his son on. And if we did a trial in front of that judge, he would tell the parties, hey, just want to let you know, Scott has represented a family member in a particular matter. I raise that up. If anybody has any objections, now would be the time to do it. No one ever raised an eyebrow. And once again, I never got any favoritism. In fact, it always seemed like he was ruling against me. So it is what it is. So let's talk about this. I think this is a case where maybe the defense may have overplayed their hand. Now, the judge in this case, Judge Morphy, he hasn't done anything wrong in this particular case. And sometimes the devil you know is better than the devil you don't know. The chief judge, when they decide to appoint a new judge to oversee this case, they will literally, put all the names in a hat, pull one out. You don't know who you're going to get. Frankly, if I was going to be in a situation and I knew the judge and I knew how he operated, that is better. And frankly, even if there was some sort of relationship, but the judge disclosed it and the prosecution doesn't object, I figure that can't hurt in one way or the other. I'm not exactly sure why the defense did it. We've mentioned this before, and I don't think anyone else has mentioned it, but the firm, McDermott, Stewart, and Ward. I know all of those attorneys. Sean McDermott, we've done cases together. Martin Stewart, we've done cases together. Tom Ward, we've done cases together years and years ago. Drew Nielsen, She was a public defender in a courtroom that I did a lot of court-appointed work early on in my days. So we were in the same courtroom. We talked a lot. We had companion cases together. She is a great, great attorney. I know of Iris Eitan, but I don't think I've had any cases directly with her. But the thing that I think is interesting, nobody else seems to mention, is that Drew Nielsen is married to Tom Ward and McDermott, Stewart, and Ward. So you would think that maybe if there's something there, maybe the prosecution's going to file and say there's a conflict that may carry over. Now, I don't think there would be. I'd have to go back and take another look at it, but they would probably get some sort of waiver. But, pillow talk at night, you never know. If things go sour for the relationship between Miss Dark and Mr. Morphew, you never know what they will claim, and maybe somebody sold them out in some particular way. I think I would have held my cards a little closer to my vest on that particular case. And when you have a judge who, although was a criminal defense attorney in the past, doesn't necessarily mean he's going to rule in your favor. In fact, usually means he may not, but you never know when you don't know who your new judge is going to be. So be careful what you wish for. I guess time will tell whether it works out to the benefit of Mr. Morphew or maybe to his detriment. Next on the docket, remember that sentence for the truck driver whose brakes failed and received a 110-year sentence? Well, the governor stepped in, kind of ignoring all of his own rules, to grant clemency. That's right. Governor Jared Polis has commuted the sentence of the truck driver convicted of causing a horrific 28-vehicle crash that left 4 people dead and 6 injured. Rohel Aguilera Mederos, 26, was sentenced on December 21st to 110 years behind bars after a jury convicted him of vehicular homicide, reckless driving, as well as mandatory sentencing, first-degree assault, and attempted first-degree assault charges. Now, he had been hauling lumber down a steep grade on Interstate 70 in Jefferson County when his brakes failed. The truck reached speeds of up to 85 miles per hour before ultimately crashing into stalled traffic, setting off a chain reaction crash and a fireball that melted cars and parts of the highway. Now, prosecutors said Aguilera Mederos' failure to use the runaway truck ramp amounted to a crime. Miguel Angel Lamas Arellano, 24, William Bailey, 67, Doyle Harrison, 61, and Stanley Politano, 61, were all killed. The governor stated, "I believe you deserve clemency for several reasons," Polis wrote in a letter to Aguilera Mederos on Thursday. "You were sentenced to 110 years in prison, effectively more than a life sentence for a tragic but unintentional act. While you are not blameless, your sentence is disproportionate compared with many other inmates in our criminal justice system who committed intentional, premeditated, or violent crimes." Polis said that Aguilera Mederos' highly unusual sentence highlighted a lack of uniformity between sentences for similar crimes, especially crimes with mandatory minimum sentences. The governor further explained, "The length of your 110-year sentence is simply not commensurate with your actions, nor with the penalties handed down in other or similar crimes. There is an urgency to remedy this unjust sentence and restore confidence in the uniformity and fairness of our criminal justice system, and I have chosen to commute your sentence now. At the end of the day, this arbitrary and unjust sentence was the result of a law of Colorado passed by the legislature and signed by a prior governor, and is not the fault of the judge who handed down the mandatory sentence required by the law in this case. As such, it falls on me to take action to ensure that justice is served in this case, and I am doing so with the limited commutation." Now, reactions to Aguilar Mederos' sentence range from skepticism to outrage. The judge who handed down the sentence expressed mixed feelings at sentencing, saying that while Aguilera Mederos needed to be held responsible for his actions, he would not have issued a 110-year sentence, the mandatory minimum under current sentencing guidelines, if he had discretion under the law. Now, Polis himself had come under pressure to take action. More than 5 million people had signed a change.org petition calling on Polis to commute the sentence. Even prosecutors wanted the sentence to be walked back a little bit. District Attorney Alexis King had recently asked the court to reconsider the sentence, and a hearing had been scheduled for January. Now, King, however, expressed disappointment that Polis intervened instead of letting Jones, the judge, determine the appropriate sentence. She stated, "We are meeting with the victims and their loved ones this evening to support them in navigating this unprecedented action and to ensure they are treated with fairness, dignity, and respect during this difficult time," District Attorney King said in a statement, according to the Associated Press there. Now, King had previously said that her office would ask that the sentence be reduced to 20 to 30 years, and Polis emphasized in commuting Aguilera Mederos' sentence, he wasn't absolving him of the jury's guilty verdict. "The crimes you're convicted of are serious," Polis wrote. 4 individuals lost their lives and others were seriously injured because of your bad decisions. The families of these victims will never again have the chance to embrace their lost loved ones. Now, Polis also recalled Aguilera Mederos' own words at the sentencing hearing when he said he was often questioned why he survived the crash. "You have wondered why your life was spared when other lives were taken," Polis said in his letter, and he says, "You will struggle with this burden of this event for the rest of your life, but never forget that because of this event, countless others will struggle with the loss of their loved ones or injuries as well, and you will serve your just sentence." Polis also renewed his call to review the Colorado criminal sentencing, mandatory sentencing scheme that is in place here in Colorado. I have never been a fan of mandatory minimum sentences. They take away the discretion of the court, people that are supposed to be smart. They know when somebody is convicted of a serious violent act or an unintentional act, but the law requires the elements that were shown, they were proven beyond a reasonable doubt to have to be sentenced, but they have to have that discretion. They should have that discretion. So let me know what you think. 110 years, did he deserve it? Did the governor make a mistake commuting the sentence down to 10? And under our system here in Colorado, that's right, he will be eligible for parole in about 5 years, maybe just a little less. Let me know. Leave a comment below. Next on the docket, Elaine Maxwell. Now, right before Crime Talk stopped last week, before we went on our little excursion, which I got some good video, and hopefully we'll be able to get that up here in the next couple of days, Gillian Maxwell was found guilty of all but one of the counts in her federal indictment. Specifically, Miss Maxwell was convicted of sex trafficking underage girls. Now she faces up to 65 years in prison. Now, prosecutors alleged, obviously, that she helped a longtime friend, that guy named Jeff, procure and sexually abuse girls for decades. Now, Miss Maxwell's brother, Ian Maxwell, told reporters that he anticipates his sister will not take some sort of plea deal. The prosecution confirmed no plea bargain offers were made or received prior to the trial, and nobody expects that she is going to roll. Now, I don't know why people think, oh my gosh, she lost. What's she going to do to save herself? Listen, if she had an opportunity to save herself by proffering and giving evidence and agreeing to testify against other people, she would have done that long ago. Not really much use in it now at this point, and so, frankly, why do it? Gillian Maxwell has some issues on appeal. Will they prevail? I don't know. She still also has the 2 perjury counts that need to be tried as well. So let's talk quickly about what is going to take place at sentencing, okay? And this happens quite a bit where the press says, oh my God, she's looking at 80 years, 60 years in prison. Well, let's take a look at what she may really actually get, okay? First, let's jump over here to our projector. This, my aficionados, is a federal sentencing guideline table, okay? And each offense is given over here on this side, an offense level. Each offense is given an offense level. At the top is the criminal history. Now, as you can see on this chart, what you do, like all charts, is you would come down and say, let's say somebody's a criminal history category 4 and their offense level is 23. And that's kind of a starting point that one would look at in this particular case. Now, first, what you have to do is you have to say, all right, what is the offense charged in this particular case? Specifically, Gillian Maxwell was charged under 18 United States Code, Section 2423, which is basically travel to engage in commercial sex act or prohibited sexual conduct with a minor. Okay. And then there's several things that you have to look at when it comes to the federal sentencing guidelines, okay? And these would be aggravating factors in this particular case. Let me just show this to you. So when you do the federal sentencing guideline, obviously you look at the offense that's charged, you plug this in, and you used to have to do this the old way, but now you can do it by computer. But there's several things you have to ask. In this particular case, was the defendant a parent, relative, or legal guardian of the minor? No, they were not. Why does that matter? Because points would get added. The minor was otherwise in custody, care, or supervisory role of the defendant. Maybe not maybe. We'll leave it there. A participant unduly influenced a minor to engage in prohibited sexual acts. We're going to do that, yes. And you can see there are other questions that go down here. And then when you get to the adjustments, it's not a hate crime, not restraining the victim, it's not a serious human rights offense, aggravated mitigating role. May be able to qualify for a mitigating rule, which would be 2 points off, but we're just going to go keep it rather safe. So what does this chart tell us? It states that the base offense level is a 28. A participant otherwise unduly influenced a minor to engage in prohibited sexual acts, plus 2. This is a 30. Now, understand there may be some other things that we're not aware of, but in this particular case, we're trying to be conservative as possible. So what does that mean? As far as we know, there's no criminal history for Elaine Maxwell that would bump her up. So we're going to assume for this case that she is a criminal history category 1. So she is right there. So she starts as a base offense level of 28, which comes out to 78 to 97 months. All right. But then you have to go up 2 points because of the minor engaging in sexual prohibited conduct. So that bumps her up from a 28 to a 30, assuming she still remains a criminal history category 1. The exposure that she has on that particular charge is 97 to 121 months. So basically she comes out there 8.5 to 10 years is where she comes out on one count. Now remember, she was found guilty of 4 of the 5. So in theory, the court could say separate victims, and I'm going to make these all consecutive, or she could run them concurrent. So really what she's looking at is 8.5 years to 10. So really she's looking from 32 to basically 40 years on the guidelines. Now what can happen is they'll be arguing about guideline levels. Maybe she was found guilty, but she's a minor participant. So maybe she goes back down here. And they will argue about that. The attorneys will argue about what level she is supposed to be at. And remember, these federal sentencing guidelines used to be mandatory, right? They were like a mandatory minimum. And so all you could do is argue for a particular range in there. And then a Supreme Court case came down and said, you know what? Hey, these judges are supposed to be smart guys. The federal sentencing guidelines really tie the hands of the court. So we're going to say that's unconstitutional. But since they spent a lot of time and money on creating the federal sentencing guidelines and coming up with just about every scenario one could possibly anticipate, the court said, well, we got to at least consider these. So this is a starting point, okay? The defense is going to file a motion for downward variance saying, hey, judge, you found her guilty, but look, she's lived pretty much law-abiding life the rest of her life. She deserves a little credit for that because no sentence should be greater than reasonably necessary to promote respect of the law, deterrence, and provide for the real rehabilitation needs of Miss Maxwell. Now, obviously, Miss Maxwell is 60 years old. She just had a birthday. She's probably going to die in prison unless she gets some relief from the appellate courts. So hopefully that explains it, because people always talk about what the maximum penalty is. They never really get around to what it really is going to be. Now, in this particular case, the court, just like in any court, can impose the maximum penalty if they choose to do so. But they have to be able to explain why the sentencing guidelines, a starting point, one factor to be considered, and then the factors under 18 United States Code 3553A were not appropriate, and why the maximum penalty is appropriate under this particular circumstance. So I hope that explains how that comes out. Maybe a little difficult on the podcast if people are listening, because remember, if you can't watch us, you can always listen to us by downloading Crime Talk with Scott Reich on all of your podcasting apps. All right, before we continue with the dumb criminal of the day, let's take a quick recess. Please Go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. And finally, our dumb criminal contestant of the day. Now, you're probably wondering who won the dumb criminal contestant of the year. Well, the Crime Talk crew, we were out last part of last week, and we haven't tallied all of the results. So we will have that for you hopefully by tomorrow. But our dumb criminal contestant, our first dumb criminal contestant of the day for 2022 is a Connecticut man who allegedly faked a positive COVID-19 test that was submitted to a judge. Now, this was according to an arrest affidavit. Investigators this week charged Junior Jump, Jumpp, with a pair of felonies, forgery and tampering with evidence for his alleged scheme to avoid appearing for a November 30th bond revocation hearing. That means the judge was going to revoke his bond and send him back to jail. Well, Mr. Jump had been ordered to appear in court for allegedly violating his release terms in a pending criminal matter. The Hartford resident's records show was arrested twice in November while out on bond in his original case. That's usually enough to do it when you pick up new cases. So, the November 30th court hearing was scheduled to review Mr. Jump's apparent noncompliance with the bond terms, and it could have resulted in immediate detention. Well, Mr. Jump is facing a variety of criminal raps, including breach of peace, threatening, and interfering with police. Jump is also facing separate felony charges stemming from his alleged fabrication of documents that were submitted as a defense exhibit in the criminal jury trial back in May of 2019. And on November 29th, Jump's lawyer told prosecutors and the judge that his client had texted him a screenshot purporting to show a positive COVID-19 test notification from St. Francis Hospital in Hartford. In response, the judge excused Jump from appearing at the courthouse. Then, in a November 30th email to the judge, Jump wrote of the test positive for COVID, but noted that if you still want me to come in, I will, because with all due respect, I feel as if you may want to raise my bond today. However, a subsequent police investigation determined that the positive test proffered by Mr. Jump was fabricated. Now, Jump's motive for faking the test, investigators contend, was to skirt the bond revocation hearing. And Mr. Jump was arrested and booked into the county lockup on a $25,000 bond. The two felony counts carry a minimum of 1 year in prison and a maximum of 5 years. Mr. Jump is scheduled for court on February 3rd. Yes, ladies and gentlemen. Good teachable moment here by Mr. Jump's conduct. Don't lie to the court. Bottom line, don't lie to the court. And Mr. Jump put his attorney in a very precarious situation, and obviously the attorney was saying, it's being represented to me that this is a valid test. The attorney is not in trouble at all because he's representing what the client has relayed to him. However, I'm sure the attorney is going to be a little more careful with anything that Mr. Jump represents as being true. You don't lie to the court. The attorneys can't knowingly lie to the court. And bottom line is, in this particular case, Mr. Jump probably should have just not shown up for court instead of trying to get out of court with a lie. You know what the big thing is? You've heard it before. Usually whatever you did is not that big a deal until you lie about it. So that's where we are. All right. Thanks for watching. We'll see you next time on Crime Talk. Don't forget to join us tomorrow, 6 p.m. Mountain Time, for our first live show of the year. We'll talk to you later.